So good morning, good day, and good evening to all. Welcome to this session hosted by Intellect Management Services and Dennenmeyer. Specifically, my colleague Alexander Gagnes. He is a member of the Dennenmeyer IP consulting team, and he is based in Munich, Germany. He has over 10 years experience as an IP consultant, working with companies from around the world, helping them to develop and secure their competitive edge with an IP strategy and understanding how to mitigate intellectual property risk and the valuation of their IP. He holds a master's degree in intellectual property law and management from the University of Strasbourg. And I am Erica Smith. I am with Intellect Management Services. I too am a consultant specializing in intellectual property rights and business development. I also have a master's degree from the University of Strasbourg in intellectual property law and management. So today the session will be for 1 hour, and we have really tried to make it as practical and as interesting as possible. So I hope you will find it useful. In terms of housekeeping, we ask that you allow us to make the presentation and then we will take some questions. We promise ample time for questions. I see a raised hand already, so I will allow Chinedu, who I know is from Nigeria, Lagos, to speak briefly, and then I'll turn you over to Alexander. Go ahead, Chinedu.
Can you hear me?
Yes, we can hear you.
Hi, Erica, and it's a pleasure being on this important platform. And I just want to congratulate you and your colleagues for putting up this. It is timely, and I think we all need this, especially in the season and times that we're in with respect to intellectual property. So I just want to say congratulations for this, and to promise you that we will be involved all the way through, and we'll be listening and also be participate all through the programs. Thank you.
Thank you, Chinedu. Thank you for joining.
Thank you.
Okay, so now I will turn you over to Alexander. And you have permission to share, Alexander.
Good, thank you very much, Erica. I think you should all see my screen now with the presentation on. Well, thank you very much for having me. Erica made a great introduction, so there's not much more to say about me actually, but for you to have just a little overview on who I am working for, I just want to make a brief introduction about the Dennenmeyer Group. Dennenmeyer was originally founded in 1962 as a patent and trademark attorney law firm, and we expanded over the years. By now we are one of the largest intellectual property service providers in the world. We cover 180 jurisdictions, over 3 million IP rights, patents, trademarks, designs are under my colleagues' management. And we have offices around the globe, over 20, and we have over 900 employees and associates across the whole world. So the Dennenmeyer Group consists of several entities. So there's not only the consulting team that I'm working for. The consulting team was founded in 2016. And as you can see here on the slides, we offer, let's say, individual consulting service around the world of intellectual property. It's about IP cost excellence, how to save IP costs. It's about IP intelligence and insights, how to generate great insights from the IP landscape. I am responsible for IP risk and due diligence, so how to mitigate risks that can arise from intellectual property topics, and also IP strategy development. That's what we are talking about today, and also the topic of IP valuation. Besides consulting, we also have the associates still. This is the patent and trademark attorney law firm. We have the state-of-the-art IP management software suite DIMES. We have IP maintenance services from Dänemeyer IP Solutions, and we have Dänemeyer Optimine. It's an AI-boosted semantic patent search tool that makes patent searches available and understandable for everyone. So this combination makes us the sole full-service provider for global IP management. And now, enough for the advertising. Let's dive into the topic. And as Erica already said, we want to make it as practical for you as possible, but still I want to give you a little briefly, not a theoretical introduction, but some introduction on the whole topic of IP strategy. What is it? Why is it important? And what do you have to really be aware of? So in our practice, in our everyday work, when we do consult our clients, we say that a successful business model has three main pillars. So first, the right market, and second, the right product or service, and third, and that is important today, the right use and protection of intellectual property. When I say intellectual property, I mean a wider definition of intellectual property, which is not only patents, trademarks, and designs, but it can also be your know-how. It can be individual recipes. It can be your clients' lists, your customer lists. It's everything that's in your head that makes your business unique and that makes your business very special. So when we now talk about IP strategy or IPR strategy, it's very important that an IP strategy supports and strengthens your business model, and that it is aligned to the market and your product and service. That means your business model needs to be protected, and your business model needs to be, as I said, protected by IP, and needs to be exclusive. With IP, you can exclusify your business model, your products, your services. And what is important, IP is not just something for the drawer. Even as a small company, it has to be managed actively, and only then you can ensure that a value added is realized. So what exactly is an IP strategy? Yeah, you can say, and it is indeed so, it's an integral part of your company's success, and not only for the large corporations, also for the smaller companies, because to be successful on the market, you have to, an IP strategy has to be a part of your business strategy. So in the end, it's all about creating sustainable advantages. Wait a second. So here you got the laser pointer. So in the center, you see it's all about sustainable competitive advantage. You need to be better than your competitors, no matter in what business you are in. You need to be better, and being better needs to last. And for this, you have actually three main strategic pillars. You have your business strategy. What do you want to do? Or what are you doing? Where are you doing? And with the support of whom are you doing it? Etc., etc. And the second one is your innovation and R&D strategy. So what are the ideas that you want to pursue? Maybe you have one product in the market, but will that be everything for the rest of your life or your business life? Probably not. You want to innovate. You want to develop something new. And that's why, especially as your business will be growing over the time, you need an IP innovation and R&D strategy. And third, you need an IP strategy, of course, because, as I already said, you want to make your competitive advantage and your ideas exclusive. You want to protect them from the competition so that they cannot imitate it. Maybe you want to earn money in the future with your ideas, not only by selling them, but also selling or licensing out your business or whatever you're planning to do. And for all of this, you also need an IP strategy. Also in terms, for example, where do you want to go with your idea? Do you want to stay in your local market, or maybe do you want to expand to another countries near you, or do you want to even expand further and broader and to completely new market? All of that needs to be taken care of or thought of when you are applying your IP strategy, and this IP strategy must be consistent with your business strategy. So what is an IP strategy in a nutshell? It's a plan of action to utilize your company's intellectual property to realize a sustainable competitive advantage on the market. So when we are looking at IP strategy, basically, you can map them across 4 poles, very generic. I mean, in the end, every business has its own strategy, but there are some basic assumptions that you can make. So you can already try to like map it to one pole more than to the other. For example, you have here the offensive IP strategy. That means in the enforcement aspect. Maybe you have already heard of so-called patent trolls. They acquire IP, which also you see here. They acquire IP only to enforce it. They are buying patents just to sue others and make money from suing, or then from forced licensing. That is maybe not a very nice IP strategy to pursue. Yeah, but that's also a valid one, and that is used by many entities. In combination with that, you have the acquiring IP strategy. That is more focused on buying the IP instead of developing it yourself. So you, for example, you buy patents that are fitting to your business model, and then you are commercializing them. So maybe you license them out, or you produce the patented products yourself, or produce goods under the trademarks that you have acquired. For many, many small companies, we are more here in this sector, in the defensive and developing IP use. So the defensive is more like the protection aspect. You have a great idea, you have something that is very valuable to you, what you think that is very sought on the market, so you want to protect it, and that's why you use IP in the defensive way, especially through patents or maybe through trademarks that secures the source and the origin of your goods. And then you, of course, also have a developing IP strategy. There you really focus on your own developments, on your innovative capabilities to bring the best out and to secure them as best as possible. And over the course of time, as you will develop your business, maybe your strategy will also shift, maybe from defensive to developing to offensive. And so at the beginning, you have one patent and one trademark. So you are really here at the bottom of the space of this coordinate system. And then over time, you develop new IP. You have more patents and different trademarks. And then at some time, maybe you will see that somebody is copying what you're doing. So you want to enforce your IP strategy. So you are more here in the offensive sector. And then at some point in time, you might realize that somebody has something in IP, patents, trademarks that is interesting for you, and where you think that could be something that you could really make a use of. Then you would think of maybe you acquiring this IP and commercializing it yourself. So you see, an IP strategy is not static. It's dynamic, it's constantly in development and constantly changing. So that's just a brief introduction on how a generic IP strategy can look like and what are the typical characteristics. And before Erica will then continue with the fun part of the practical application, I would like to give you a brief overview in a nutshell. So what have we learned? In principle, your IP strategy has to be aligned to the corporate strategy, and also it should be linked to your research and development and innovation management. So every time you invent something new, you should look at it from the IP side. So what do I have here? Is it new? And maybe can I secure it with intellectual property so nobody can copy it, so that I have it exclusive? And then you can also look, what kind of IP strategy do I want to use? Do I want to be the offensive kind? Do I want to rather only for the defensive use? Do I need to acquire some IP because I do not have it myself, but I want something that is really great? Or will I focus on developing new IP? So that is the basic consideration, but how to start now? As a first point, it is very, very important to analyze your environment, to analyze your own strengths and weaknesses. Who is around you? Who else might have great ideas? What are your own strengths? What are you doing good, and where can IP further help you? What are your weaknesses? Is there any open flanks, so to say? Do you have really great stuff developed or invented, but have not yet protected it by IP? That is a typical IP weakness that you might want to address then. And then always when doing business, think of how intellectual property and intellectual property rights can contribute to your business success. So always keep the business in mind, and always when doing the business, keep the IP in mind. And then really to get started, look at what you have at the moment. What is your core innovative inventory, so to say? What is your idea? What is your business? Look at what you need, look at what you have, and look at what you need, and check where the gaps are, also in terms then maybe of the protection. Do you use a trademark, for example, for your company name? Do you use it in public? Do you have a trademark for it? If not yet, maybe that's a gap you would need to fill. Apply for a trademark for your name. Do you have an innovative recipe for something? Consider protecting it in some way. And then very easy, or not very easy, but very straightforward, develop a roadmap with concrete steps to implement your IP strategy. And exactly that's where I want to hand over to Erica, because she will also give you an example of how such a roadmap together with the development of a company, of a small company, can look like. And with that, I, from my part, say thank you for your attention. I would say that we put the questions in the end, if you are okay with that, Erica. And otherwise, please feel free to reach out to me if you have any kind of question around intellectual property. And yeah, with that, I would say I stop sharing my screen, say thank you, and hand over to Erica.
Thank you, Alex. I will now share mine. So. Okay, so having had that background from Alex, it's my job to answer this question. Is IP strategy relevant for small businesses, for SMEs? Is IP strategy relevant for developing countries? Often IP is discussed as something for industrialized, developed countries, but we will have an answer by the end of my presentation, I hope. So first, we consider exactly what are the uses and functions of intellectual property in SMEs. And there are many forms of IP. As Alex said, you can have a very broad approach to IP. And within the context of the SME, first, we're usually talking about unregistered trademarks, where the entity will use a name for their product or service. And at the very least, it's understood that it is necessary to have some differentiation in the market, some ability for consumers to know where the product or service is originating. So the unregistered trademark in that environment serves primarily as an indicator of source and as a tool to generate sales. Thereafter, maybe with time and awareness, the SME will understand the importance of registering the trademark. And why do you register? You register to ensure you have greater legal certainty around the use of the name, and to ensure that you can benefit from the exclusivity that comes from having a registered intellectual property right. As the business is developing, there's a greater understanding about the need to build an awareness of your brand, but also you are looking more at your pricing strategy. Of course, you're seeking to increase sales. And if you're fortunate enough, if you are successful with what you're doing, there may be opportunities to even consider licensing the trademark for others to use. So I'm going through this. This is not necessarily linear, but this is often how IP is used by SMEs. And we will have a very practical example. So you will see how these are applied. Often with SMEs, the level of innovation may be such that they are not looking at having a patent. As we all know, patents can be fairly complicated, they can be expensive, and usually there's a heavier reliance on the use of trade secrets and contracts to maintain confidentiality and to keep the innovation exclusive. Also to ensure that you're able to maintain your competitive advantage by being able to offer something that other people do not have access to. So it's not as complicated. SMEs will look to the use of trade secrets. These are free, and the main challenge is to ensure the secret is actually kept a secret. Now, in terms of designs, also known as industrial designs, these are applied as the business seeks to stand out more in the market. So initially, you may offer a product. As time goes on, you look more at how the product is designed to ensure that it's more attractive to consumers, to ensure greater differentiation in the marketplace. And importantly, where you can, you should seek to start registering these designs, again, to ensure exclusivity, to allow for better enforcement. Of course, you will be building the reputation of the business based on its design. So, you know, if you have a well-packaged, attractive product, consumers will be drawn to it more. Designs help to build your brand awareness. And of course, they have an impact on pricing. So the better designed the product, the better price you can usually command. Now, when you speak with SME owners, there is usually some awareness of what a patent is, and that it will allow some advantage in terms of exclusivity. But the challenge is usually one of cost. However, as the business develops, and if you are engaged in a lot of technical and product innovation, you should consider the use of patents in your strategy. Again, and you will see for all the IP, the registered IPs, and trade secrets as well, the aim is to have exclusivity, to allow for enforcement, to build your reputation and brand awareness, to allow you to be able to price, command better prices, so premium pricing, for example, to improve your competitiveness, and to allow for opportunities for licensing. So what does it actually look like for SMEs? And this is a more pictorial representation. So here we show different categories of SMEs, and these categories are based on those developed by the consulting company McKinsey. So at the very bottom, you have the informal micro businesses. And these are actually, in developing countries, about 70% of all businesses. So these small informal entities, as I mentioned before, we're looking mainly at the use of unregistered trademarks and trade secrets, sometimes contracts. As the business develops, You have locally focused small businesses. Again, they tend to use unregistered trademarks. Maybe they may have a registered trademark or a geographical indication is used. Or they may be using trade secrets and contracts. You have another category which are known as stagnant, struggling, medium-sized businesses. They tend to have unregistered trademarks. Maybe they've registered their trademarks, and maybe they use trade secrets and contracts. Now, look here, when we are seeing a growing medium-sized business, we expect that in our environment, maybe they're still using unregistered trademarks. At this stage, they should have been transitioning to register their trademarks. They're going to be using trade secrets and contracts, designs, and possibly patents. And then we have two categories, the startups, where we have the established startup and the early stage startup. So where we're looking at startups, we're thinking about companies that are specifically or especially in the technology space, and they're really being developed with investment in mind. So they're going to have or should have a different approach to IP strategy and management, where they're having their rights registered. You may still see unregistered trademarks, but the difference between the early stage and the established startup is that with the early stage startups, they more than likely would not have yet registered their designs or patents. So that's just a general overview. And of course, nothing is set in stone, and you will see variations. Now, I'm going to give a very simple example, but one that is very relevant, I believe, to our environment. So in the case of Barbados, and generally throughout the Caribbean, condiments is a big business, so to speak, for SMEs. And here I've shown you some photos of a seasoning, a marinade that is typical for Barbados. And you see the various brands, and there are many, many more brands on the marketplace. So how would IP strategy apply to the seasoning? So we go through a timeline, so to speak, for this condiment business. So usually these will start out as cottage industries, home-based businesses, very small micro businesses, and they will have a secret recipe. So there are standard ingredients for making this marinade, but everyone will have their variation to try to stand out in the market. So they will have a name and they will have a secret recipe. As the business grows, so they're starting to develop a reputation, people are asking for the product by name, they have increased sales, and you start to see that transitioning where the business organization is becoming more formalized. And it is at this point that you really start thinking about, I need to ensure I have really good systems in place to protect my recipe, because that's the source of my competitiveness. And I need to protect the name of my business. So that's when you start thinking about registering the trademark. You really pay attention to your internal systems as far as the protection of your recipes concerned. And it's interesting we're speaking about recipes because for those of you with some experience in IP, you would know that recipes are or can be very difficult to protect. So it speaks to having internal systems and control systems to ensure that the recipe for the condiment is not disclosed. And as the business continues to grow, its market share starts to increase. They're starting to be more innovative, coming up with more recipes, variations of the products. And there is a real focus now on growth. And this is where there's an increased awareness in terms of I need to be protecting my brand. I need to take steps to ensure my people know the brand, more people know the brand, and you're really focused on growth. After some time, you may determine that you have reached your maximum potential in the local market, and or there are opportunities for growth outside of your domestic market. So you're looking at export. To enter the export market, you're really going to start thinking more deeply about your IP strategy. Maybe you would have registered your trademark locally, but as you consider your target markets, then you start thinking, okay, I need to have my trademark registered in the target markets as well. You're going to be thinking, how do I ensure I keep my recipes secure? And generally for this type of business, it means that you will control manufacturing, but you will enter into distribution arrangements. And in those distribution contracts, you have to consider IP. For example, there's a case, a real case out of Belize. Their products, they're under the name Marie Sharp and condiments, and they were exporting to the US. They had distribution contracts, but they did not register the trademark in the US. And what happened was that the distributor registered the trademark in the US and owned the rights to the trademark there. And that caused a whole heap of problems for Marie Sharp. In fact, it caused them to have to register a new trademark and reissue their products under the new trademark. So you have to really think carefully about your IP as you enter the export market, and how will you enforce your IP. So the business is still growing. You have gone from being an informal micro business to one that is now exporting. And at each step, we've seen that there are IP strategy considerations. And finally, you reach a stage where you have a brand that is very well known, it's attractive to consumers, and you have been focused on Barbadian season, Bajan seasoning. But there may be an opportunity where, I don't know, let's say Grace Kennedy out of Jamaica, they recognize this is a well-known trademark, this is a well-respected product, and we would like the opportunity to use the trademark and to benefit from the goodwill of that trademark and the reputation. And we're going to, instead of applying it to seasonings, we will now be applying it to hot pepper sauces. And this is what is meant by brand extension. So you would have over time built up your reputation, built up your brand, so that there is an opportunity now to license the trademark for use by third parties and thereby generate a source of income. So if you think through the stages I just mentioned, and you think back to the background on IP strategy Alex would have taken you through, you see how this can all be applied to a small condiment business in Barbados. So is IP strategy relevant for SMEs? The answer is definitely yes. And Finally, just to wrap up and to give some practical advice. So having looked at an example which is based in the food and beverage industries, we remind you that your biggest IP asset, your most valuable, will be your brand. And a brand is not just the name, but it wraps in your reputation, your design. So you need to take the steps to protect your brand. You should proactively consider the IP implications in your innovative activities. What does this mean? How is a small condiment business being innovative? Well, we're talking about reviewing documented changes to your internal processes. So you may find that over time, you make changes to how you process the condiment, how your operations are set up, which allow you to be more efficient. You may make tweaks to, or you may come up with little bits of machinery to help you with your processing. You will come up with new formulae and recipes, and you should be documenting these and assessing them from an IP perspective, meaning, are these innovations valuable? Can they be protected and made exclusive to your business? So you shouldn't take these things for granted, but start thinking, how do I benefit or maximize my benefit from these innovations? You should create internal policies addressing IP issues. So things like confidentiality and secrecy. Reminding employees of the trade secrets and why they should ensure they don't disclose them. Access to information such as contracts with distributors, suppliers, pricing lists, all of these have value. So you have to have policies which address how these are dealt with. You should always ensure you have formal contracts in place, not only with employees, but with external contractors, which seek to protect your business secrets, your technology and processes. You need to have your contracts reviewed carefully to ensure that where rights might be transferred, your interests are protected, and to address situations where, for example, employees and external contractors may create or invent something of value to the business to ensure that the rights are transferred to the business. Finally, and this is something that we in the region really fall short with, is that you should understand and appreciate the value of data. So to the extent that you're able to do small surveys, gather customer feedback and gather consumer data generally and analyze it. This helps you to understand your market. It helps you to understand what your competitors are doing better than you and how you can improve it. And it helps you to protect your brand. So that was a short summary where we applied IP strategy in a practical way to an SME. So we will now open for questions. Thank you. I hope it was understandable and relatable. So are there any questions? Okay, we have a raised hand from McCarthy. Go ahead, McCarthy.
Okay. I just wanted to say, with respect to couple of things in respect to, let's say, take patents.
Mhm.
We are in the period of the pandemic, and there would have been, or most people would have seen or heard that the world was asking the Americans to relax their patent protection on the vaccines. Actually, what they were actually asking them to do is not to relax the patent protection, because the TRIPS agreement makes provision for a country to declare a medical emergency, and in the context of a medical emergency, the government could give its manufacturers a compulsory license to manufacture the product. The reason, and India could have done it, because India is the largest producer of medicines, by the way. The reason they couldn't do it is that although the Indians have the patent in front of them and they can read it and know how to work it, they needed some additional information, which was protected by the protection that's given to undisclosed test data and test secrets and business secrets. So therefore, although they had the patents in front of them, because they lacked that other part of the information that would allow them to manufacture the product in the same way as the United States people did, they couldn't move forward and give them a compulsory license. And interestingly, with respect to medicines, India has a clause D3 in its patent law that says you cannot get a patent on a medical, or anything for that matter, if there is not a substantial difference between the original and the new thing you're trying to patent. Because the Americans in America, the bar to get a patent is very low. So in a medical thing, you would have medicine that is effectively at 60-year patent protection, because the owner of the patent would simply modify or rearrange a couple molecules in the device or medicine and claim that he made a substantial improvement on the art. And they would give him a patent for another 20 years. That prevented the Indian generic market from really growing. But in the 1990s, they changed their law to require that it must be substantially different and better than the previous one. And right now, with respect to the pandemic, the focus is switching from vaccines to therapeutics. So Merck, as well as Pfizer, have come up with what they claim to be a new therapeutic drug, or two new drugs, each one of them has one, that for which they have patents in the United States already. The Merck print drug supposedly cost $700 for a 5-day treatment. There is an old medicine that has no patent protection for ivermectin that works actually better than Merck's new drug. It also works better than Pfizer's new drug. The cost of a 5-day treatment of the ivermectin is 53 cents for the 5-day treatment. However, people who are in positions of power in certain countries, the United States in particular, have said loud and clear that we are not allowing the old medication to be used, because they're using a spurious argument that the same medication is used on animals. But we
Yeah.
used, yeah. So with the question of protection of trade secrets, it is not always in favor of poor developing countries, because if you can't get access to the balance of the information that you need to be able to produce a non-patented product, you're stuck.
Right. So McCarthy, I appreciate what you're saying. In this scenario, though, and yes, the issue of access to medicines and the patent system, we could have an entire week speaking on this issue, and ensuring the rights to access, especially for poor developing countries. We can't do it today. But what I will say is that even though there are some controversies surrounding the use of the IP system and things like know-how, there are potential benefits for businesses in these territories who are seeking to grow and develop. What we need to figure out, I think, generally as developing countries and small territories, is how can we start making use of the IP system in such a way that it truly benefits us. So your point is taken, and maybe we should have a session to discuss these issues. But I would still argue that there are opportunities for SMEs to use the system to their benefit. And there is a question from Carrie Ann Bell. She says, in order to protect IP and prevent employees from disclosing recipes and methodologies, is requiring the signing of an NDA the only method to achieve this? So Alex, I will give a response and allow you to also respond. Carrie Ann, I spoke of this example of Mary Sharp in Belize. And what is important is not only the signing of the NDA, but your entire internal processing system. So for example, what they had to do was they broke up or divided their manufacturing process so that there were 8 employees and only half of them knew half each of the rest. So none of them knew the entire recipe. Only of the 8 employees, 3, which included 2 of the owners and 1 manager, only those 3 persons knew the entire process and the full recipe. Other than that, they took steps to ensure that the employees only knew part of the recipe and part of the process. And this actually turned out to be really important, because what happened was an employee who was with them for 5 years left, returned to Guatemala, and tried to replicate the processing system and recipe. But because he did not know the entire process or the full recipe, he was unable to do so. So it's not only about having them sign agreements, it's about taking actual steps to ensure and maintain secrecy, whether it is in terms of how you design your manufacturing process to other things like keeping the recipes in a safe or a vault at all times, limiting access, etc. But I'll allow Alex to give his perspective.
Actually, Erica, there's not much to add. This is a perfect example that you brought for like how can trade secrets be protected even in the smallest of businesses. Fabulous, fabulous hands-on approach here. I mean, there are hundreds of measures how to safeguard trade secrets in large corporations. I've done projects about that topic in China, for example. I went through whole factories and inspected all of the offices and premises, whether there's a potential for know-how leakage. But that is actually something for big organizations. I think what Erica just said is the perfect example how it can work out even for the smallest of entities. And in general, yes, NDA is always important, but try always your best on how to protect it with the measures that you have. And I think that splitting up the manufacturing process and the need to know basis for everything is a very good way to start really with the basics. And also a very practical and hands-on advice is try to be nice to your employees, because if you scare them off and they run away and they would start their own business. I had this case once, not fortunately not in my company, but with clients that I've been working for. Yeah, so that's also a very easy, practical, hands-on advice.
Thank you, Alex. I don't know if there are any other questions or comments. Okay, well, if there are no more questions, we can end the session. We recorded it and we will disseminate it online and make it available on demand. But other than that, thank you all for joining us this morning. I hope it was useful. Thank you, Alex. And we look forward to doing another one sometime. If you have, sorry, go ahead, Alex.
Just wanted to say thank you very much for having me. It was a pleasure. Unfortunately, not live in Barbados, but yeah, still I have caught a little bit of Caribbean feeling here in Munich.
You're welcome, Alex. And if you have any questions, remember you can reach out to either Alex or myself, and we're happy to help you along the way. Thank you, everyone. Take care and goodbye.
Bye.